Welcome back, and here we are. I hope you've all had a lovely morning tea, wherever you may be. Feet up, comfortable on the couch. Settle in now for our legal superstar, also known as the world's best lawyer, Paul Gordon, who's now a partner at Orphan Lawyers. Welcome, Paul.
Thanks for having me.
If you're active in Social Media Club Adelaide, you'd be very familiar with this guy who is so generous with his time, answering probably what is the most basic questions around copyright, defamation, and other laws that govern how marketers can legally operate in this country. Just a bit more about Paul in case you've missed it in previous years. Paul has a broad commercial skill set with specializations in the areas of technology, media law, intellectual property, and corporate governance. He is one of Adelaide's leading experts on social media and privacy law, and having been recognised in Doyle's Guide for leading technology, media, and telco lawyers, and for leading intellectual property lawyers. Paul provides advice, and if you do have any legal queries, we strongly recommend that you contact him outside of this forum. Paul does have Discord open at the moment, so if you have any queries as the presentation's going, feel free to address him at Paul Gordon in the Discord chat, and he'll try to get to your questions in the session. Paul's got a pretty full presentation today, and we're really, really excited to have him. Thank you again for your time, Paul. Look forward to your presentation. So without further ado, let's cross to the Orphan Lawyers office in King William Street in the city to Mr. Paul Gordon.
Hello, everyone. It's lovely to be here. I always love being involved in Digital Adelaide and Social Media Day. I think it's one of the best events in the sector around the country. So great work to the team for putting it together, a great event in unusual circumstances. As Rabina said, I have got Discord open, so if I'm ever looking to the side, that is the reason why. The challenge for today is I can see when people put up GIFs or memes out of the corner of my eye, so if you can put up a relevant GIF to distract me, that's the challenge. We also have our first question, which is whether or not the best way to cook a brisket is unwrapped, wrapped in butcher's paper, or wrapped in foil, from Ryan. So that's very relevant to what we're talking about today. And my answer is wrap in pink butcher's paper once you hit the stall. So I'm going to be talking about the large and generally scary world of digital law, but whilst I might scare you a little bit, let's try and keep it a little bit more upbeat and give it a bit of a different title. Before I go any further, this is the usual slide to say that I am a lawyer. I'm talking about law, but this is not legal advice. I haven't considered your circumstances. Before you rely on anything I'm about to say, particularly with respect to cooking brisket, consult a lawyer. And if you need to consult a lawyer, those are my details. I'm also available for Microsoft Paint editing if you need it. I'm pretty awesome at MS Paint. Photoshop scares me. But anyway, that's where you can find me. So today, look, it's a slightly different from the title, which was Digital Triage, but the issues that I'm going to be going through are what I have seen as being the major areas in which crises arrive over the last 12 months. And that's really been in the areas of privacy, liability for online content, which includes social, but also it can be on websites, adverts, etc. If we have time, we'll do a copyright deep dive and then Q&A. Loving the GIFs, Christy in particular, that one is amazing. If you're not on Discord, you're missing out. So let's talk about privacy. And I've covered a number of these topics in other sessions, either at Social Media Day or Digital Adelaide or other social media sessions that we've run. So I'm not going to go through the full gamut of any of these topics, firstly because I've done it before, and secondly because we don't really have time. But I'll just do a very quick refresher. So as you may recall, hopefully, that there is no right to privacy in Australia, but we do have the Privacy Act. And the Privacy Act applies to people and organisations who have a turnover of $3 million a year or more. So I'm afraid all of you one percenters who are earning more than $3 million a year, you personally have privacy obligations, but as do companies. Health and fitness are also covered by the Privacy Act, and people who deal in data. So if you're buying or selling data, then you are caught. And the one area where people sometimes forget that is if you're selling a business that includes customer information, you are then dealing in data, even if you weren't previously caught by the Privacy Act. And what that means is that if you're not in any of those categories, you don't have to worry about the Privacy Act. You can go and deal with people's information as much as you like, and there's nothing much they can do about it. If you are working for government, be it Commonwealth, state, or local, if you are working for a government instrumentality like a university, then you've got your own set of privacy laws called the Information Privacy Principles, and that is what's going to govern what you do. Talk to your in-house legal about that if you are in those various areas. This all covers personal information, which is pretty much anything from which a person's identity can be determined. So it could be someone's voice, it could be their image, it could be a picture of their car with a personalised license plate. All of those kinds of bits of information are personal information, even though it isn't clearly stating it as someone's name. If someone who knows the individual would be able to identify them, that is enough. But in Australia, you can do pretty much whatever you like with someone's personal information as long as you tell them what you're doing. So you don't need consent to collect, use, handle, store, disseminate personal information, except in some very limited circumstances. You do, however, have to keep it secure, and that's where we've had some pretty significant issues in the last 12 months, mainly in the area of ransomware. So I've had a number of clients come to me in the past 12 months where their systems have been hit with a ransomware attack, and even though the ransomware attack isn't aimed at accessing personal information, the fact that the hackers had access to the system is enough to mean that you have privacy law issues arising from it. In terms of consent, you only need consent when you're dealing with sensitive information, so that's health, medical, political affiliations, sexuality, race, religion, etc. If you're keeping any of that information, you need consent and it can be withdrawn. Or if you are using the personal information to market to people, which I'm assuming a lot of you will do. So if you are using remarketing techniques, if you are tracking people with pixels, then you are using their personal information for direct marketing, and you need either their consent or for them to reasonably expect that you would be doing the direct marketing with that information. We've just had a question on TikTok, Chrissy. I will get to TikTok when we get to copyright, so that is absolutely on the cards. So since last year, when we talked about all things privacy, we've had a few pretty significant things happen. Firstly, Facebook has been sued by the Information Commissioner, which is interesting. As someone who has currently got 3 or 4 matters against Facebook, I wish them luck. It is good fun trying to pin Facebook down. Apologies to Facebook if anyone from there is on this webinar. If you can let me know how I can serve papers on you, I'd be really grateful because it is frustrating. But that's going to be quite significant as to whether or not they are deemed to have breached privacy. And then we've also seen a number of cases taken by the Information Commissioner about work practices which have disclosed personal information unlawfully. So we had a group of psychologists who refused to hand people's information back to them. We had Spotless fined for disclosing the names of certain employees to a union. There was a company who got in trouble when they used information for direct marketing that they got from a third party. So they hired an agency to gather information on potential customers and then use that list for cold calling. Because they didn't inform the individuals at the point of collection that they had that information or how they got that information, they were then fined. Now, the interesting thing here, and what can give you all a little bit of relief from any concerns about the Information Commissioner SWAT teams coming through your windows, is that in all of those cases, the monetary damages were actually quite low. So the Commissioner can fine individuals up to $370,000 per breach and companies up to $1.7 million per breach. But each of these fines were in the order of $3,000 to $6,000. So it's, to be honest, I'm a little bit surprised by how low those fines were, but that's what's happened so far. And it's really interesting to see what information has been the subject of breaches. So the majority of it is contact information. The Information Commissioner puts up a quarterly report on what privacy breaches there have been over the preceding quarter. And that means these are only situations where there have been breaches which have been deemed to potentially cause serious harm to the people whose information is exposed. So if a company has a data breach and they don't think it's going to reasonably cause serious harm to people, they don't have to report it and the numbers don't get into these graphs. So I find it actually quite interesting that there has been over 400 cases in the past quarter where just contact information has been disclosed, and that's been deemed to be serious enough that it would cause harm to the people whose information was disclosed. I mean, financial details, you'd expect that health information, tax file numbers, etc., absolutely understand why that would cause serious harm. If it's just someone's name and address, that must be an interesting context in which it occurred. And the majority of it has been because of malicious and criminal activity, which once again is surprising. I mean, that's a lot of malicious activity going on where people have lost information, 64%. 32% human error. The number of times I get calls saying, sorry, we emailed the information to the wrong person is too many to actually count. And then 4% system faults. And in terms of the malicious attacks, they're mainly cyber incidents. So it's your ransomwares, your hacks, etc. Rogue employees, keep your employees happy because they can absolutely take your information away. Social engineering is actually lower than I would have expected. And the theft of paperwork or data storage devices, another one. We just pointed out that there was a little bit more than a small fine for a Spam Act breach, and that's absolutely right. So for those of you who didn't follow it in the news, Woolworths copped a consent fine of over $1 million for breaches of the Spam Act, where they were sending marketing material to people who did not ask for it, and when they asked to unsubscribe, didn't unsubscribe them. And so the the ACMA took them to court, and then through consent orders, they were fined a massive amount of money. So it's generally a good idea to not only have an unsubscribe link in all of your external communication, but actually let it work. So if someone asks to be taken off, take them off. The other thing that's been quite prevalent in the one we talked about it last year, and I think we'll continue to talk about it for some time to come, is the GDPR. For those of you who haven't heard me talk on this in the past, it's basically the European privacy law that came in 2018. And the GDPR came in with much fanfare because for the first time it was an external facing law as well as internal facing within the EU, which means that it doesn't just apply to companies in the EU. So basically when it came in, everyone freaked out. For Australians, it's important to know that there is no monetary threshold like with the Privacy Act. So you might not actually be covered by Australian laws, but you absolutely are covered by European laws if you offer goods and services to people in Europe, or you monitor the information of people in Europe. And there's a lot of conjecture as to whether or not that's only EU citizens or EU permanent residents, or if it's just an Australian who happens to be checking their email from Strasbourg. They have significant penalties, and there are much more stringent obligations on you because you need consent from people to collect their information under the GDPR, sensitive or otherwise. You also have to provide them with a right to be forgotten and to withdraw their consent at any time unless you have a legal obligation to hold on to that information. If you are monitoring information in the EU, or you are offering on a regular basis, you also have an obligation to have a person on the ground in the EU to take on any privacy complaints that you get. So it's pretty draconian, it's pretty strong. Oh, sorry, I'm just back on the Spam Act. Chrissy wants to know how the unsubscribe button didn't work. Was it a deliberate act? Look, I don't know the exact detail. My understanding was that they had an unsubscribe link, but when it was clicked, it didn't actually remove people from the database automatically. And that was the breach. But I'm happy to take that on notice and provide a little bit more detail when I can. So with the GDPR, there's been a lot of debate as to when things kick in. So if you have a website that happens to allow people to order things from Europe, then are you caught? I'd say probably not, unless you are actively promoting it as offering worldwide shipping or offering services worldwide, or having things that allow for translations, currency conversions, that sort of thing. In 2019-2020, there were 340 cases with over 158 million euros in fines, the biggest of which was to Google. The smallest fine was €90, which makes you wonder, why did they bother? I went through and I had a look at the various cases that came up in that period, and not a huge number were outside of the EU. I mean, Google was one of them. In general, it has been the large players outside of the EU who have fallen foul of the GDPR, although there are some cases in relation to smaller entities, but generally then that's quite egregious breaches of privacy of people in the EU. So there was a firm that was running political ad monitoring, and they breached privacy of people in the EU because they were working on an EU-based campaign. Even though they were based in Canada, they were then taken on for GDPR breaches. Ryan has clarified, thank you. They had customers in their database sharing email addresses. If someone used that email, using that email unsubscribed, they only unsubscribed that user. They didn't unsubscribe the other users sharing that email address, as they assumed they were separate users. There you go. Thank you, Ryan. Also a question, does that mean GDPR doesn't apply if you're sending from servers in the EU, but you are sending to AU emails? Jasmine, that is absolutely correct. The only time the GDPR will apply is if you are collecting information of people in the EU. So your data hosting provider in the EU may have GDPR obligations, but you as an Australian company simply using a controller, is what they call it. So you would be a controller, sorry, a processor in the EU doesn't require you to comply with the GDPR. If, however, you are collecting information of anyone who transits through the EU or anything like that, you absolutely could be caught. It depends upon whether or not it's a once-off or if it's something that happens on a regular basis. So these are the kinds of things that you need to be concerned about. Do you sell private service to people in the EU? Does your site offer currency conversion, translation, or specifically mention EU countries? Are you systematically monitoring information about people in the EU? So if, for example, you have Google Analytics and you are seeing significant traffic from the EU and you are able to identify personal information from those analytics, then that might be an issue. If you are collecting information about people's criminal history in particular, it doesn't matter how small your operation is, that is automatically caught. So we have had some clients in the past who are doing checks on potential employees or who, because of anti-money laundering legislation, have to monitor activity in the EU, and that becomes problematic for them. Obviously, if you are concerned that a non-South Australian contestant will win Master of Back to Win, you are with me. I know I'm conflicted. I was Team Callum, so anyway, that's my heartbreak. So that's privacy. So if anyone has any other privacy questions, now's your time. I will give you 5, 4, 3, 2, 1. Awesome, no privacy questions. If you have privacy questions, you can absolutely still put them in. So the other major development that we've had in, thank you, Chrissy Laura, we've had in the law has been to do with online publication. And in general, it relates to defamatory content, misleading, deceptive conduct, or breaches of advertising standards. There's also copyright breaches that we've seen issues arising. And the major development has been in terms of responsibility for content online. The major question that we see is who has published content? If you're working for a marketing agency and you are distributing content from a client, who is responsible for that content once it gets out there into the wild? In the case of allergy pathways, which is one of my favourites, I mentioned I think every presentation because I just think it's amusing that you could try and cure peanut allergies with acupressure. I don't know, maybe you can. Apologies to you acupressure enthusiasts out there. But in that case, the court said that the meaning of publish is to make known, sorry, I'm covering my own quote, which doesn't help me, or to produce a thing for publication. It can mean to expose or display to public view. And this case basically arose from the question of whether or not a company was responsible for comments posted on its website and for comments posted on its social media channels. And it all came back to this case law from 1937 about bulletin boards. And the question there was, if I have a bulletin board and someone posts up a notice, at what stage am I responsible for that having been published? The court in that case held that once it was brought to your attention that it was there, if you had control of that bulletin board, you were responsible as if it was your document that had been posted on there. And so we developed this system through allergy pathways and other decisions about a requirement of monitoring and acting upon notifications of improper content being posted on a channel that you control. So the ACCC basically said the amount of time that you can take to remove content depends upon your size, the size of your social media following, how reasonable it would be for you to take something down. So if you are a multinational company with lots of resources, you have to take it down quicker than if you are a mum and dad operation operating out of your lounge room. And that was also something held up in the Smirnoff Advertising Standards Board case. But now, unfortunately, you may have to start being a little bit psychic. And the reason for that is the Dylan Voller case. Now, this one was a pretty high-profile case when it came out. So Dylan Voller was the young man who was in detention at the Dondell Corrections Facility in the Northern Territory, and he was photographed in a spit hood tied to a chair. There was lots of controversy as to the appropriateness of the restraints and breaches of human rights. A number of media organisations published stories about this, in which they encouraged comments on their page, but also they pushed it to their social channels and allowed comments to be made by the public on those stories. The public was a little bit, well, very harsh and posted some absolutely disgusting comments about Mr. Voller, and he was less than pleased. He, without any notice to the news companies in advance of this, commenced proceedings against them for defamation. And the media companies said, well, hang on a second, this isn't our content, we didn't publish it, you didn't tell us that you were concerned about it, so what's the problem? The court held about a year ago that on the limited question of who had published the content, the media companies were responsible. Now, we don't have a decision as to whether or not the comments were in fact defamatory or whether there are defences to defamation, but on the question of whether or not it was the media companies who had published the content, the court in New South Wales said, sorry, media companies, you pushed people to these pages. You encouraged them to make comments on the content, and you used really inflammatory headlines in an attempt to get more clicks. There's a lot of evidence about the amount of money and incentives that were provided to journalists at these organisations to try and get more engagement on social. So that was a single judge, and no one really did much about it. There was a bit of uproar at the time, but it went on appeal pretty quickly to the full bench of the New South Wales court. That court, about a month and a half ago, upheld the decision. They upheld the fact that if you are a publisher of content and you have a public-facing page that you control and have the ability to deal with, you are responsible for the content that is posted on it. And whilst the full court didn't deal with this issue, the original decision included a comment that you have that obligation before the content is displayed to the public. So it's not just you have to check it on a reasonably frequent basis. It was that you are responsible before it even appears on your page. And whilst it had been pointed out to the court that, well, there's no real function in Facebook, for example, to allow you to do that, the court said, well, make one up, duct tape it together. So what the court said everyone should be doing is having content filters on all of their digital outlets, which are normally used for profanity filters, and just add common words to it, and, the, but, a, etc., to try and capture everything. And through doing that, you can then moderate the content. Doesn't help if people use intentional misspellings, doesn't help if people use images which may contain text. But the court didn't seem to really think about that. So unfortunately, the position at law at the moment in Australia is that you must pre-moderate any content that third parties put out there. So if you are running a campaign that requires, a competition that requires third parties to put up commentary, if you are hosting a website of some kind, if you have any kind of outlet where people can post commentary, then you are responsible. And that also, does having posting rules on your pages avoid your responsibility? No. So if you've got something up there that says you are responsible for what you post and you mustn't post anything defamatory, but someone posts something defamatory, you are still responsible. You can't contract out of that obligation. So it's left us in a really weird position. Now, I'm sure the case is going to be appealed to the High Court, whether or not they agree to hear it, who knows. But when it was just one judge in New South Wales, the rest of the country could kind of say, yeah, that's relevant, but it's not binding on us. Now that it is a full court decision, it becomes highly persuasive for other full courts and also potentially binding on single judges in proceedings around the country. So the landscape has unfortunately changed, and where you are dealing with high-risk matters, you need to be incredibly careful about allowing people to post things online and being really vigilant to prevent commentary coming up there. Unfortunately, I don't have an answer for you as to a neat legal way to get around this. I mean, it's great news for us lawyers because it means there'll be a bunch more cases. I mean, I must admit I have used in a case the Voller argument about some rather unflattering things that were said about a client, and I will continue to do so because that's now the toolkit I have to play with. But for people who are running digital content, it can be really scary. The other thing that we've seen more and more of is influencer issues. So people who are either putting themselves out there as influencers and not disclosing that it is in fact an advert, or people who are using a photograph of someone to imply that they endorse a particular product. That is not a new issue, but it is one which has continued to bubble away, and I think we're going to see more and more of it. We've seen recently the interesting issue of Ivanka Trump and her beans advert, which was confusing on many levels. But that was if that were to happen here in Australia, there may well be issues with respect to whether or not it's misleading and deceptive conduct to not disclose if that was done for a political purpose or for a commercial purpose. In general, there are significant issues with using influencers who don't disclose whether or not they are being paid or being given a benefit to post a comment. Similarly, if you are using someone's image without their permission, even though it might be an image that you own from a copyright perspective, you may still fall into difficulty if they say that you're implying an endorsement that doesn't exist. I'm going to, sorry, the AANA code came out where it basically said that do you have a reasonable degree of control over the material? Does the material draw attention to the public in a manner calculated to promote a product? And if so, there's no require to label it as commercial. I just don't agree with that. I'm sorry, AANA. I think that if you have provided a product to someone with the expectation or hope that they will give it a positive review and you've provided it to them for free, then you're giving them a benefit. There's an incentive for them not to be honest with their review, because if they give it a bad review, they are less likely to get another free product from you. So I'm a bit more conservative than the AANA on that, but use your own conscience, I guess. A case which has come out very recently that is of major concern to anyone who uses ClickWrap, so that's your standard terms and conditions on your website for whatever it is you're doing, is one to do with unfair contract terms. It used to be that there was this regime of unfair contract terms. Adelaide, Glen Adelaide, South Wales, Cosy classes influencers. Content appear on other pages paid for by clients, but doesn't do much sponsored content. Generally, yes, that if someone has received promotional collateral or payment for something and is advertorial, there may be an obligation to tag it as such. It can be a grey area depending upon what's going on there. I wouldn't want to comment on any of those particular cases. But the general position is that if you are being paid for something and you are putting it out there as if it was not an advert, then you may be engaging in misleading and deceptive conduct and you may be breaching advertising standards codes. Unfair contract terms. So almost every website uses some form of ClickWrap, be it a box that you have to click or just terms and conditions at the bottom of your website. And for a while now, there has been a law which says that if you have a standard form consumer contract or a standard form contract with a small business, you cannot include unfair terms. And up until now, there's been very little guidance from the courts as to what unfair means. That changed about a month and a half ago with a decision involving Bendigo Bank, where the question in the context of a different act, that was under the Asset Act, was asked as to whether or not their terms and conditions were unfair. And so we now have a bit of guidance as to what will be or won't be unfair contract terms. Generally, anything unilateral will be skirting the line of being fair or unfair. So if you have the ability to change your fees without their consent, or if you have the ability to modify your offering without notice, that may well be an unfair contract term. If you have indemnities in place, so one of the big ones which has been identified is that there was a case where a company said, you will indemnify us for any loss or damage we suffer as a result of providing you with our services. Reasonably standard sort of thing. What the court said was, well, that doesn't make sense because if the customer has no control over it, if it's not their fault or their action that caused your loss, why should they be indemnifying you? That's unfair. And the other thing is that there's an imbalance in rights. So if you have full control of how services are provided and the customer doesn't, then you can be reasonably sure that that's an unfair term if you want to control things via the contract. So unless you are allowing your customers to negotiate contracts with you and make amendments to it in a bona fide, in a real way, you probably have a standard form contract. If you're consumer facing, it's definitely a consumer contract. If you're small business facing, it's probably a business contract, small business contract. And so you need to be really careful that your contracts aren't entirely invalid because they contain unfair contract terms. That's another fun one that's come up over the last couple of months. And now we're going to what was going to be topic number 1, and I forgot to change the slide, copyright. Now, the reason why I'm going to do in the next 8 minutes a copyright deep dive is because this continues to be an area that I get a lot of questions on a bunch of the different groups that I'm involved in. And whilst we've gone through some of it in previous years, I think it is still important just to have a quick refresher. So copyright is an IP right that protects the original expression of an idea. It does not protect the idea itself. And we've got some lovely flowery wording about clothing an idea in material form, which basically means that I can have a great idea. If I tell you that idea, that's not protected by copyright. If I write that idea down, the form of words I've used to describe the idea are protected, but the idea itself is not. Once again, Microsoft paid skills are amazing, just so you know. And copyright provides you with the right to reproduce content, the right to publish it, communicate to the public, perform it, adapt it, transmit it, broadcast it, and transmit it. So that basically means that anything that is created by you in the context of a digital campaign or anything else is going to be protected by copyright. But it also means that if you are using memes or images you found online, then you may be infringing copyright through your use of it. And it covers basically any form of expression, so writing, images, sculptures, dramatic works, musical works, sound recordings, cinematograph films, which is just a fun word to say, so basically movies, as long as they are substantial. And so there's been a whole lot of commentary as to whether or not something is or isn't substantial. There was a case taken against the panel back when that was a show as to whether or not its use of clips firstly fell within fair dealing exceptions. So those are the get out of jail free cards, and also the whether or not they were substantial enough to constitute a copyright work. But there's really inconsistent guidance as to what is or isn't substantial. So for example, supercalifragilisticexpialidocious is substantial, whereas the man who broke the bank at Monte Carlo is not. Exxon is not, but 'twas Brillig and the Slithy Toves was. So if you think, oh, I'm just using it a little bit, it doesn't have copyright, maybe, maybe not. It all depends upon how iconic or how substantial it is in terms of the impression it leaves a reader or viewer of the content. The other thing is that it must be original. So if I was to reproduce, for example, the content of the phone book, that's not original. I'm not actually turning a mind to it. And this becomes really interesting when we have AI-created content as to whether or not something that has been created by a machine is the copyright of the person who created the code. And where machine learning comes in, we get into a really interesting area. And my favorite case on this actually involves a monkey, where, I'm not sure if people have seen this, there's some great articles in the New Yorker about it. A photographer dropped his camera in an area that was filled with monkeys. One of them took the camera and took an amazing photograph of itself with the camera, smiling at the camera, and the photographer then tried to enforce copyright over that image. But as he hadn't taken the image, he didn't own the copyright. So you need to be the author. It needs to be created with independent intellectual effort, skill and judgment, or use some form of creative spark. Even Rebecca Black's Friday probably qualifies for protection. And it is owned by whoever created the content. So if you are, as an agency, creating copy for your clients, unless there is a contract or something in writing assigning that back to your client, you own it, which means you can do what you want with it after it has been used for that client. We often have people get very confused by this and think, well, hang on a second, I paid for that content, surely I own it. That's not the way it works. If you are an employee, your employer does own the content. That's the only time that really changes. Or if you are taking portrait photography, for some reason, portraiture is owned by the person who commissioned the portrait. You're welcome, Nat. You are absolutely welcome. Often we find orphan works. That means a work which you find online which you can't work out the creator of. In other countries, they have provisions with respect to orphan works. In Australia, they don't, which means that you can't use it even though you can't figure out who owns it. And it runs for 70 years after the death of the creator. Or the death of publication if there's no identified creator. And Chrissy, that is actually a really good case to reference. Now, I'm not sure if people saw what happened with the bit of a social media stoush between She Digital and South Aussie with Cozzy, but basically content was created by She Digital for a client. The client, thinking that they owned that content, gave it to Cozzy. Cozzy used the content, and based on that use, there was a complaint made by She Digital saying, hang on a second, you're using our copyright content. The challenge there is that Cozzy did not know that the content wasn't in fact free to use. And so there was a legitimate complaint against his use of it because he didn't have copyright authority to use it, but he was acting in good faith. And so it becomes really a difficult situation if you don't know the provenance of the content you're using, which is why it's always important to ask the question of your clients, okay, you've got this photography or this video or this copy, do you own it? And ideally, can you prove that? Because if they can't, you're putting yourself at risk, remembering that the publication is by you if you're the one putting it out there. This is where, you know, links, copyright, the Voller decision, all together. The other thing is to remember that your copyright rights may be limited by jurisdiction or time or use. So it might be that you have, as in the case of the Lucy Corn's Cozzy issue, the client did have a license to use that material, but only in a limited manner. And so it was the use of that material in a manner not contemplated by the license that caused the problem. So really interesting sort of area to think about is, what am I allowed to do with this content when it's given to me? You may think that you can get away by saying that this is all fair use. Keep in mind, fair use does not exist in Australia. It does exist in the US. And here we have only fair dealing, which allows for a limited use of materials. So it must be for your own research and study, for criticism and review, satire and parody, reporting of the news, or providing legal advice. And if you don't get into those areas and it's not public domain, you need consent if you want to use a substantial part of copyright material. Which brings us to, I'm going to skip through, to Chrissy's question of TikTok. TikTok, in my opinion, almost certainly infringes the copyright of the individuals whose music is being used in that medium. Now, I think that the political satire TikTok, so, you know, the Andrew program, you know, this is not your, you're in charge of this interview, mine, or the misogyny speech TikToks and all those sorts of things, those I think would absolutely fall within the fair dealing exception for parody or satire. However, if it is me lip syncing to Rebecca Black's Friday, firstly, what's wrong with the world? But secondly, I'm almost certainly breaching her copyright. And even though I'm only doing it for a short burst, it is still a breach. And that's different from the position in the US, where fair use would most likely cover that usage. So APRA, which is a collecting society, so an organisation that goes out and collects money for performers and producers of content, has been lobbying for TikTok to actually do the right thing. I think the problem with trying to take action against TikTok is they're not based here. So it would just be an absolute nightmare if you were going to try and get TikTok to cough up the cash. That may well mean that they are going to, thanks Kevin, I kind of do. They are going to most likely have to go after individual creators, which is not really economic, because if I go after that 14-year-old who's breaking out some dance moves, firstly it's a bad PR look, and secondly unlikely to have much money. But if brands start using TikTok and if brands start using copyright material, that's when I think we're going to start seeing cases brought against them in relation to that use. So the question about TikTok is, TikTok and its use of data, do you think the government is likely within its right to shut it down in Australia? So beyond the copyright question is the question of data security and sovereignty. And under existing laws, unless it was able to be shown that TikTok was providing the information to foreign governments or that it was using it in a manner which was inconsistent with the Privacy Act, I think it would be a little bit challenging for them to shut it down and take it and get rid of it without new legislation, which is entirely possible, or even regulation under the Privacy Act or other data security measures that there are. At the moment, I think that it is only likely to happen in a political context rather than in a more cybersecurity context, just because of the nature of what TikTok's been used for. But I mean, it is still mining a huge amount of data. I mean, just people's faces and identities is massive. So I think it is entirely possible that that may occur. It could also be through sanctions that against China, that TikTok could be shut down on that basis, in the same way that Huawei has been blocked from the 5G network. TikTok, as you would have seen in the recent full-page adverts in The Advertiser, are really wanting you to know there's nothing to see here. It's perfectly fine, perfectly safe. I don't have a TikTok account, not only because I lack coordination, but also because I think it is a little bit creepy. But at the end of the day, unfortunately, you have to go where the people are, and people are on TikTok. So I think at the moment, you're going to have to weigh the risk of it being shut down versus the reward of engaging with people on it. But if you do engage with people on it, I would strongly encourage you to consider what material you are actually using to ensure that you aren't breaching someone's copyright. Now, other quick thing, one day I'll get to change the slide about Instagram, because we've been talking about official regramming for years. I think, in fact, Rubina would have been the one who mentioned that regramming was coming, possibly even last year. My last check was that there's no official regramming allowed at the moment, but please feel free to correct me on Discord if that's wrong. But that means still, regramming is copyright infringement. Never forget. So, the only other thing to remember with using copyright content is that consent is one thing, fair dealing is another thing. Neither of them get you past moral rights. So if you got the permission of a company to use material on your digital channels, they don't own the moral rights of attribution and integrity that the author of the material does. So they might have, Jimmy in graphic design, who's created some content that you're using. If Jimmy wants his name on it, you may have to put his name on it, even though you have the consent of Big Bad Corporation to use the content. Vice versa, if you have Jimmy's permission to use it, you would still need the corporations consent to use their copyright material if they own it. So moral rights are something that you can't really get out of unless you get waivers from the individuals who created the content. Right, so resharing on stories is now able to be done. Thanks, Christy. So that will be fine, go for your life, but regramming is not. Remember the distinction. So, do you have to credit everybody every time? Depends on the context. If you're doing sign writing, you probably don't. If you're using someone's photograph, you probably do. There we go. Only 7 minutes over time. I think that's not too bad. Do I have time to quickly touch on Facebook competitions and what isn't allowed as entry mechanisms? So many businesses ask people to share this post, which I thought wasn't allowed. Do any pages actually get shut down if they're not following the rules? So the rule against share this post or tag in this post, etc., is a Facebook term and condition, not a legal requirement. There are huge amounts of regulation of competitions in Australia that are legislative requirements, and those are things like whether or not it's a game of chance or a game of skill, whether or not your prize pool is over a certain amount, whether it's open to people in different areas as to whether or not you need permits. In terms of the Facebook competition rules, that is, as I say, their terms and conditions. And it does seem that people get away with it quite a lot. Enforcement is very patchy. I think will continue to be patchy for some time. Unfortunately, there's not much more I can say than don't do it, and if you do it, expect you might get caught, but maybe you won't. I think that's probably all we have time for at this stage, unless anyone tells me otherwise.
I would say so, Paul. Thank you so much. It was really worth giving you that extra 10 minutes. Thank you for touching on TikTok as well, both from the copyright perspective, but also the more recent, more pressing issues around data, what it's tracking on your phone, where that data may be going. And again, thank you so much for your time. Fantastic presentation. I loved your Instagram slide, personally. There's been some great questions too from everyone. If you want to watch it back, this will be available, as will all other sessions, live on demand. So we're just going to take a quick couple-minute break to switch over, and we'll be back with Ryan Jones talking about websites.